Welcome back. I'm Ladan Korhani. So I have explained to you how to bring an application to court and how to respond to an application. Now, there's going to be circumstances where it is very urgent and you need a court order either on the same day or within a few days. And so bringing just the application may not be sufficient. In those circumstances, what you would be doing is you still have to complete all the documents that I indicated you need for an application to bring to court. But in addition to that, you need to do there's two different forms depending on the urgency. Um, you need an affidavit, which is a Form 14A, and you need a Form 14B for circumstances where it is not feasible or advisable or recommended for you to serve the other party. So a situation where you're fearful that if you serve the other party, they're going to take reprisal. And there's so many different scenarios. You would better be speaking with a lawyer about that. But if it's urgent and you need a court order on the same day, you bring a 14B motion and a 14A affidavit. Now, how I like to explain this is the 14B motion is what? So when the judge is reviewing it, they want to know, what are you looking for? What are the court orders you want? Do you want a restraining order? Do you want custody? Do you want specific parenting time? That is the Form 14B. You fill it out and you have to put on there without notice, meaning that you would be getting a court order on the same day and you're not serving the other party because it's not recommended for you to do so. And then the next page, you indicate the orders that you're looking for. Okay, so you have to put that on. The Form 14A is a why. Okay, so the court is going to look at this and say, okay, so you're asking for the following orders, but why are you asking for it? So in this affidavit, which is a sworn document, you need to indicate the reasons why you need to have these orders and why you cannot serve the other party. What are the circumstances? Okay. You may want to give a little bit of a background because just so that you know, the judge isn't really going to look at anything else when they're making a determination on whether or not they're going to give you those orders. So that's the court calls it ex parte motions without notice to the other party. You have to know that it is not easy necessarily to get these orders. You have to show urgency. What does it mean, urgency? You need to satisfy the test of urgency. It means that you need to show that there's an imminent risk of harm, either to you or to the children or someone else, and that prevents you from serving the other party. So you need to show that. You need to show what's going on. Okay? If you don't show this, you're not going to get the orders. And usually then it's advisable that the court proceeding go on its regular path with the case conference and so on and so forth. So this is in circumstances where you're bringing a motion, you need a court order prior to a case conference. Okay? Now, there's another way of getting a motion. The other way is called an urgent motion. So an urgent motion is also brought before a case conference. And again, you do need to show the test of urgency. It's also, you have to show it. The only difference with an urgent motion is that you are serving the other party. So you still you use the Form 14, which is a notice of motion, instead of the Form 14B. And then you also still need to use the Form 14A. So again, the Form 14, the notice of motion, is the what. What orders am I looking for? And then the 14A is why. Why am I looking for these orders? So you complete this. This needs to be, the 14A needs to be commissioned. by commission of oath. The court clerk can do that for you, and you serve it on the other party. And the other party has 7 days to respond. If they don't respond, it goes to the court, or the judge rather, and you will get an endorsement on whether or not you're going to get your orders. If they do respond, it still goes up after 7 days to the judge, but with the understanding that the other party has responded. That's with respect to ex parte motions and urgent motions. Thank you, and until next time.